Here in Las Vegas, thank you for your patience and indulgence. Appreciated it. And we will now open the hearing on SB 303. This revises provisions related to the protection of children. Senator Scott Hammond, welcome to the dais, sir. Ms. Duffy, welcome. Appreciate you being here and look forward to your presentation.
Thank you, Mr. Chair and members of the committee. I have some remarks prepared so I could walk through the bill with everybody, tell a story a little bit, but one of the things that I may lose pretty quickly, down south I have a psychiatrist, Dr. Durrett, and I think she's at the table still. We might lose her any time, so I'm not sure if we should go directly to her in case there are members who have questions for her, because one of the things that we are talking about in the bill, it talks about the psychology, I suppose, of a child who's been in the care of one family for a number of years, and then, of course, if you try to remove them, what happens to that psyche of that child. And so if it would please the chair, if you would like to hear that testimony before I get into my remarks, that might be prudent at this point.
So just kind of a preface to what you're going to do is what we'd have her do. I know she has to see patients, I believe, and has to do rounds with her patients, and that's important as well. So
I believe
if we
so.
could give her, what kind of time do you need, doctor, to do this?
I've got a good 15 minutes to make some comments and respond to questions, and or longer if needed. I can push it to 3:30.
Okay, let's have
We'll
you talk fast and do an overview with what you want. I apologize for that, but I'm working on your time schedule, not necessarily ours. So we're interested to hear what you have to say. And if you could preface the bill with the story and the clinical information that you have, and then we'll have Senator Hammond and Ms. Duffy get into the meat and potatoes.
Thank you, sir. I appreciate your flexibility. For the record, I'm Lisa Durrett. I am board certified in both adult and child and adolescent psychiatry and serve several roles, one of which is as the training director for the Child and Adolescent Psychiatric Fellowship down here in Las Vegas and the medical director of Healthy Minds. And Senator Hammond can go through the details of the bill more specifically. What I want to talk about pertains to child development and the impact of attachment on our youngest children. My comments pertain specifically to those kids that are 6 and under, not the older adolescent population. And when we're talking about foster care, we want to make sure that we are adhering to best practice, which is a child-centered foster care model, with the ultimate goal of reducing harm to the child. It makes absolutely no sense to remove a child and then iatrogenically or by our interventions cause additional harm to the child. We know from years of research that secure attachment is a very strong predictor of future social adaptation. And the failure to have secure attachment at an early age has very deleterious effects, which include things like the behavior disruptive disorders, oppositional defiant disorder, conduct disorder, and those diagnoses and behaviors which lead to eventual problems with failure to adhere to the rules and regulations of society, success in school, and entry into the juvenile justice system. So there's long-term societal costs to having that early failure of attachment. We also know that infants and young children have a biologic predisposition to attach to a primary caregiver, and that predisposition increases gradually over that first year. In other words, that predisposition towards attachment for a tiny infant is rather different than that of a 1 or 1.5, 2-year-old, where it becomes very, very strong and significant for that young child to have a primary secure attachment figure. We also know that infants and young children cannot sustain attachments over the course of space and time. This becomes critical around the times of removal. So a child is removed for purposes of protection because of abuse or neglect. And when that child is with a primary caregiver, they're forming an attachment to that primary caregiver. They see their foster parent as the primary attachment figure. And that in of itself is a healing therapeutic relationship. When there is uncertainty of what's going to happen next, the idea of visitations and or disruptions in those attachments without a firm end goal is very disruptive to the overall development of the child. Because of this, we know that multiple placement changes in infants is associated with an increased risk of inhibitory control problems, which are those behavior problems I mentioned, oppositional defiant disorder and such, that can arise as early as age 5 or 6. These are the children that often end up receiving special education services in school because of disruptive behavior and other very costly interventions. Placement instability is associated with both what we call internalizing and externalizing behavior disorder, thus externalizing the behaviors that we see on the outside, the aggressive, disruptive behaviors, and internalizing depression, anxiety, and suicidality. And this continues through latency age childhood. So we want transitions from foster care to minimize harm. Suggestions are things such as the foster parent or the primary attachment figure being a part of visits with and reunification with parents when the ultimate goal is reunification. The idea of having a primary attachment figure for 2, 3, 4 years and then suddenly disrupting that attachment to serve the purposes of reattaching or reintroducing a biologic parent for whom they do not have an attachment is quite damaging to the child's ability to have a safe and secure development through their early childhood. And with that, I will end my comments and answer any child psychiatry or child development specific questions that you guys may have.
All right, thank you. Committee, any questions? Assemblyman Jones?
Thank you, Madam Vice Chair. So to bottom line it is, if a child younger than 5, you don't want to disrupt who they're with, even if it's a foster parent. Is that the bottom line?
Thank you. The question whether or not it's the bottom line about disrupting or not, that's not the bottom line. The bottom line is to appreciate the fact that having a safe and secure primary attachment is the ultimate goal for early childhood. And that if a disruption needs to be made, it needs to be done in the safety and best interest of the child. And to abruptly make any change in placement, especially for a young child, has very untoward consequences on their future development.
Any further questions? Go ahead.
Thank you so much for your testimony, and I know you have rounds later. Along that same line, and thinking about ways that we could prevent disruptive moves for children, especially where they come into the foster system, where placements in foster homes don't always work out, where they might move back and forth and be sometimes, I hate the term bounced around, but sometimes bounced around in foster homes. Perhaps then would it be worthwhile to consider language that would hold a foster parent to honor their commitment to keep a child in the home for a certain length of time so that moves don't happen? Or can you tell me your thoughts about how we would work on creating more permanent atmosphere in our foster care system?
Wow, that is a great question, and that's one of the ultimate questions for our foster system is how do we create future adoptive care and or foster parents who, under the child center best practice model, regard the children, at least psychologically, as their own. And they form the role of a parent just as you would for your biologic child. We know that those are the children who have the best outcomes as far as how to foster that and to create it. I don't know that answer, but we certainly need more of those homes.
A quick follow-up. Oh, perfect. So perhaps then maybe it might be fair to consider some kind of an amendment or some kind of policy by which we say that there's penalizations to the foster care system or to the foster care home for what might appear to be capricious moves of a child. I'm thinking we have such great foster parents out there, and thank goodness we do. But let's say if a foster parent moves a child for reasons that don't necessarily aren't around a child's safety, would it be fair to say that that a foster parent could become unlicensed for asking a child to be moved out of their home?
I would certainly want to be cautious of putting forth any restrictions that would disincentivize a parent from entering the foster system. We want to leave open doors for all parents to be able to engage as foster parents, and my fear would be to put those restrictions in place might turn some otherwise fabulous foster parents away.
Okay, Assemblywoman Spiegel, sorry.
Okay, thank you, Madam Vice Chair. As I was listening to your testimony, it was striking me that it might make sense for there to be a differentiation in policy based on the age of the child, and that whereas a policy that works for children 6 and under might not be the same best policy for looking at children who are between the ages of 6 or 7, depending on where you draw that line, and 18. And because as I look at the bill and I speak with people about the bill, one of the things that I keep hearing that keeps coming across is that there is no one-size-fits-all solution, and I'm wondering if a one-size-fits-all policy makes sense, and if you could comment on that.
Thank you for bringing that point up. Absolutely. It's hard to, in the child world, bring up a one-size-fits-all. And our legislation, our rules, and our regulations around the care for providing best environments for our children needs to be developmentally informed. So even to say it's just a cutoff based on chronological age is difficult, because you could have a child who is chronologically age 10 but has a significant intellectual deficit or developmental disability, which puts them psychologically at a much younger age. And so if I were to make the suggestion, changing to very developmentally informed language would be a best practice.
Any further questions? So maybe we should come back up here to Northern Nevada and let the sponsor of the bill go forward.
Thank you, Ms. Vice Chair. I appreciate the doctor's willingness to come and testify today, and of course the questions. For the record, Scott Hammond, Senator from District 18 in Clark County. I'm here to present SB 303, which is something that came to my attention during the interim. We had an interim committee tasked with talking about some of these issues, and this was one of those that struck my mind and struck me deeply. I've had several occasions over the last few years, known several families that have been involved in issues dealing with the bill itself. And so I just wanted to go through, and to begin my testimony, I want to talk a little bit about, with the Madam Chair's indulgence, I just want to talk a little bit about a story. On September 15, 2009, a 5-week-old infant I will call Emma suffered a non-accidental head trauma while in the care of her parents, a skull fracture and 2 brain bleeds from 2 different abusive events. When she was 5 months old, Emma was removed from her parents' home and placed with her current foster family. Now 5 years old, Emma still lives with the same foster family she has lived with for the last 4.5 years. In 2009, the plan for Emma was reunification with her biological parents upon their completion of certain requirements and a determination by the court that would be safe for her to return home. For 3 years and 3 months, the Department of Family Services provided assistance to the family to help ensure it would be safe for Emma to return home. The Child Welfare Court reviewed the case every 6 months to determine whether Emma would be safe and that reunification could occur. Then in January 2013, a petition to terminate parental rights was filed. During September 2013, a trial on the petition was held, and on February 14, 2014, the district court issued its decision granting the termination of parental rights. On March 27, 2014, the biological parents filed an appeal with the Nevada Supreme Court. During the appeal process, Emma remained with her foster parents. The Supreme Court granted 2 requests for extensions of time for the biological parents to file their appellate brief. On January 30th, 2015, almost 1 year after the termination of parental rights petition was granted, the Nevada Supreme Court overturned the district court's decision. During the 2 years the case worked its way through the legal system, Emma was cared for, loved, and cherished by the only family she has ever known. A bond was formed, this little girl became attached to her foster parents and they to her. At this point, Emma's case is still pending. Despite having been raised in a loving, caring home for the past 4.5 years, the courts may decide to return Emma to her biological parents, with whom she spent a mere 5 months and at whose hands she initially suffered. This bill is important because Emma and other vulnerable children need a voice, not the voice of the state, parents, or foster parents, but an independent voice that ensures a child's best interests is recognized. Emma has done nothing wrong. She was placed with a family in an environment where she has grown up surrounded by love, comfort, and stability. She should not suffer the emotional and psychological drama of being taken from the only family she has known because her biological parents and the courts allowed years to pass without definitive action. Senate Bill 303 aims to address situations like these in the interest of children's health, safety, and well-being. If you look at the bill itself, Section 1 of the bill provides that a child is, rather than may be, in need of protection if the child is in the care of a person under whose care another child has died or been abused, unless the person has successfully completed a plan for services to address the abuse, as recommended by an agency that provides child welfare services. This section also provides that a child may be in need of protection if the child is in the care of a person under whose care another child has been abused, regardless of whether the person has completed a recommended plan for services. In addition, Section 1 also defines abuse and neglect, clarifying that abuse includes non-accidental physical or mental injury or sexual abuse or exploitation that is either caused or allowed by a person responsible for a child's welfare. The definition of neglect includes abandonment or failure to provide for the needs, care, and supervision of a child. Section 3 amends existing language in Chapter 128 of NRS, which provides that primary consideration in any proceeding to terminate parental rights must be whether the best interest of the child will be served by the termination. Senate Bill 303 expands the evidence that may be used to terminate parental rights. If a child has been out of the care of his or her parent or guardian for at least 12 consecutive months, the court must consider specific factors. They must consider specific factors in determining the risk of serious mental or emotional injury a child faces by staying with or returning to the home of his or her parents. These factors include the length of time the child has been out of the care of his or her parents, placement options for the child's age, the developmental, cognitive, and psychological needs of the child, the attachment or bond the child has formed with a substitute caregiver, and whether removing the child from the care of the substitute caregiver is likely to result in psychological harm to the child, which is why, of course, we had the doctor speak just a little while ago. I thought it was very important to have that in there. This section is key. Adding this language to Section 3 ensures that the bond, the attachment, and the time a child has spent with a foster family is taken into consideration when a court determines the best interest of the child. In Emma's case, one can easily argue that it is not in the child's best interest to be uprooted from the only family she has known to be returned to the people with whom she only has a blood tie to. Child development experts have found that for a child to grow up as a healthy, functioning, and productive member of society, a sense of permanent home and family is key. Children form bonds with the parents they know, the siblings they play with, the home and environments in which they grow. Research shows that repeated transitions are often difficult on children and may affect brain development. This bill requires courts to not only consider factors such as age and length of time with a foster family, but also the negative repercussions of removing a child from the family they know and trust and the psychological harm that results from returning to a child to parents after long-term placement in foster care. Section 4 of the bill allows a court, in determining neglect or unfitness of a parent, to consider whether a child suffered a physical injury, a near fatality, or a fatality for which the parent has no reasonable explanation, for which there is evidence that the injury would not have occurred absent abuse or neglect. Finally, sections 4.7 and 4.9 expand the powers and duties of the Interim Legislative Committee on Child Welfare and Juvenile Justice to include reviewing issues and proposing recommended legislation related to the provision of foster care, including reunification. That was an amendment we added over in the Senate, thanks to my colleague, Senator Joyce Woodhouse. I thought that was a really important element to add to it, because what we're going to do is continually look at other needs that could arise that we should also consider in future legislative sessions. In closing, I've received numerous letters on this bill from families with stories similar to Emma's. There are stories. There are stories of court determinations that came years after foster families brought children into their homes, and there are several other stories that have included elements of this bill. This bill is about policy. It's about adding more consideration to the tools that justices would have in order to come to a determination of where a child should be placed. And that's what we're asking for here. We're asking for each of you, this committee, and then of course this body, to consider policy, to look at what is in the best interest of the child. And that's all we're asking for. And I appreciate the time and attention to SB 303, and I would defer the rest of my time over to Ms. Bridget at the leisure of the chair.
Thank you, Senator Hammond. Appreciate your passion and your bringing this bill forward. I know it's important to you and those who have testified. Ms. Duffy, would you like to add?
Good afternoon, Chairman Oscarson and members of the committee. My name is Bridget Duffy. I'm the Chief of the Juvenile Division for the Clark County District Attorney's Office, and I am honored to be here to testify in support of SB 303. And so you all understand where I'm coming from. I have dedicated 15 years of my career in the state of Nevada, specifically in Clark County, to those foster children. And I have served several different roles in those 15 years. I served as a Deputy Attorney General representing the Division of Child and Family Services. I have served as a Deputy District Attorney, and I have served as a judicial officer, a court hearing master, hearing cases of child abuse and neglect and dependency. And during those 15 years, I have seen good and bad sides of foster care. I have shared triumphs as children have gone home. I have seen children go home and be murdered at the hands of their parents. I have seen the joys of adoption, and I have seen adoptions fail. I have seen thousands of children in 15 years go in and out of foster care, sometimes repeatedly. It is not unusual when somebody asks me how many children I have to tell them that I feel I have 3,000 or more children, because I feel personally responsible for every child in Clark County's foster care life, that they obtain a safe, stable, and permanent home. And that is why today I am smiling and I'm happy, because I have this body to consider these children that I know through my passing conversations with you, whether I know you professionally or just through these hallways, that every single one of you cares about kids. And this is your opportunity to make some decisions regarding them. So any day our state is talking about those kids in foster care is a good day. And we might not all agree on where we're going to come down on this, but it is a good day for those kids. So what I would like to focus you on at this point is currently in NRS 128.005, we have legislative declarations for terminations of parental rights. First of all, our state has declared that preserving and strengthening families is a part of our public policy in this state, and I absolutely agree with that. In 15 years of child welfare in Clark County, we have reunified more children with parents than we have ever terminated parental rights. In 2014, 64% of the children in care were reunified versus 24% of our children that were adopted. Second declaration currently in statute is our state has declared that the continuing needs of a child for proper physical, mental, and emotional growth and development are decisive considerations in proceedings for termination of parental rights. That is currently in law. It is currently a declaration of this legislative body. In Clark County, approximately 97% of all cases that proceed to termination of parental rights, the Child Welfare Agency has provided reasonable efforts to reunify those families for at least a 1-year period. Many times it's more than 1 year. Those reasonable efforts are mandatorily reviewed by court over the course of that 1 year to determine that the services provided were appropriate and reasonable to address those issues that brought children into foster care. and place them into the Child Welfare Agency's custody. When those reunification efforts have failed, by state and federal law, the courts must identify a permanency plan for that child. And one of those plans may be adoption. It is an acceptable permanency plan. The termination of parental rights statute requires a finding of clear and convincing evidence that the best interest of the child will be served by that termination of parental rights, and it also requires that we prove parental fault. Within best interest grounds already embodied in statute, there are 12 specific considerations. There are currently 7 categories of parental fault, and within those categories, there are currently 8 considerations of unfitness. Section 3 of SB 303 adds into current statute 5 specific considerations that the court shall make when determining the risk of serious mental or emotional injury to the child if the child were returned to his parents when a child has been out of that care of his parents or her parents' home for at least 12 months. Those are the placement options for the child. And I deem that to be, do we have an adoptive placement for this child? The age of the child, the developmental and cognitive and psychological needs of the child, which, going to my colleague Dr. Durrett's testimony, that's the bright line, the cognitive needs. It can't necessarily be an age-based need. Whether the child has formed that positive bond or attachment with a substitute caregiver, and whether the removal of the child from the caregiver is likely to result in that psychological harm. Currently, the statute has a definition of injury, and that definition of injury goes directly toward the conduct of the parents, which I know is a concern for some, that this adding Section 3 is not a conduct-based, it's more of a best interest-based. But currently in statute, the definition of injury, which is the risk of injury to the child, occurs when a parent fails by act or omission to provide a child with adequate care under circumstances requiring intervention of the Child Welfare Agency. So Section 3 of SB 303 is basically now saying to the court, when considering the acts or omissions of that parent to provide a child with adequate care under circumstances requiring the intervention, we now consider 5 things. When you look at the considerations of unfitness in NRS 128-106, several of them are obviously conduct-based, but we have one consideration in 128-106, subsection 1, which is mental deficiency or emotional injury or emotional illness. Those are not necessarily conduct-based. People may be born with them or develop them, and therefore they are deemed to be unfit because they cannot provide for their children's ongoing needs. Biological parents are protected by placing a very high civil burden of clear and convincing evidence on termination of parental rights. While I am sure in the forthcoming opposition, this committee will hear the words, a termination of parental rights is equivalent to a civil death penalty, as that is what our U.S. Supreme Court has said. I don't dispute that, because it severs a child and parent relationship. But I ask this committee to also consider what our Nevada Supreme Court has said in a specific case we refer to as NDO. While parental rights have been characterized as a civil death penalty because it severs the parent and child relationship, the state has a strong interest in a just and correct determination as it seeks to protect a party's children from abuse and neglect and ensure they have a stable family life. The court expects that both the parents and the state's interest will invariably be strong in termination proceedings. Nothing in SB 303 makes it easier to terminate a parent's rights. We are not asking to change the burden of proof. We are not making it a shortened time frame to determine things. It adds mandatory considerations. We want this state and this body to say it is important for our courts to consider these things when considering the fact that these children have been in foster care for an extended period of time, which we have determined is 12 months. And 12 months is in line with many federal and state laws already. At least 12 other states have a ground for termination of parental rights that is based on the length of time alone that the child has been in foster care. At least 2 states, Massachusetts and New Mexico, have specific considerations within unfitness of a parent based upon a psychological parent-child relationship that is developed between the substitute caregiver and the child. There are other states that have just, if the child has been out of the home for 12 of 24 months, it is unfitness. Most of those states that I've cited with the 12, they have their statutes break it down to say if the court finds best interest and one of the following. And one of the following might be child's been out of the home 15 to 22 months. It doesn't say why the child's been out of the home. It's a ground on its own. After I'm concluded, you are going to hear those stories of people that have dedicated themselves to making the lives of foster children better, that they have worked tirelessly and without question to help reunify children with parents while they cared for their children. I would be happy to answer any questions that you have at this time.
Mr. Thompson and Mr. Trowbridge.
Thank you, Mr. Chair. Ms. Duffy, and I appreciate you coming to talk to me because I would have some questions. On Section 3, again, like we had talked, I know you say the 12 months, but I have to just say for the record, I'm kind of have some heartburn about the 12 months. But I also wanted to know, at what point do we look at, like if we are looking at a TPR, looking at the foster home versus the next level of kin? And because, there are great foster parents out there, but in a perfect world, to keep the kid within their cultural environment and so on and so forth, I would think would be desirable, because if there's some real big differences, that can be just as different for the kid as well. So can you explain to us if there's a really intense movement to get like the aunt, the uncle?
Thank you for the question, Assemblyman Thompson. Bridget Duffy from the Clark County District Attorney's Office. The answer is yes. We have, thanks to, again, our legislative body, we have created within law preference to place children with relatives upon removal, not termination of parental rights, initially upon removal. And our courts in Clark, and I know I have colleagues from Washoe here, have advanced and have become have gotten much better in making sure we're asking those questions up front and early. I think one way to demonstrate to you, and maybe we could do better, but of that 24% of our children that were adopted in 2014, 55% of those were adopted by relatives. So more than half. So that's good. And like I said, maybe we could do better. There's a lot of ways foster care we could do better. But this bill, I think, it gives one more thing we can do. And so we are supposed to, the court's supposed to be asking those questions along the way. There is the preference, and there's a presumption to place siblings together as well.
Okay, thank you.
Mr. Trowbridge, and then Mr. Sprinkle.
Thank you, Chairman. I received a document titled Opposition Arguments to Senate Bill 303. And in that document, it had a statement that I just talked to the lawyers about. The question or the statement is, the U.S. Constitution requires both a determination of parental fault and a finding that termination of parental rights is in the best interest of the child before the state can terminate the fundamental rights to a parent's one child. That's what it says. Is anything we're doing here in 303 going to wind up further complicating issues with appeals and going all the way to the Supreme Court, or is this quote that I read you just a real spin job?
Scott Hammond, for the record, Senator from District 18, and it's Assemblyman Trowbridge, that's a great question, and I'll tell you what, the reason why I went to, when I wanted to bring this bill, the reason why I went to Ms. Duffy here is because she knows her stuff. And, I have certain talents in this world. You just saw that she's a very articulate, very research-based lawyer, and I'm going to let her answer your question in a second. I mean, I have my own talents, don't get me wrong. A few of you guys here are probably wishing I didn't have those talents. But she has done a lot of research on this to make sure that we didn't, have that concern. So I'm going to go ahead and turn it back over to Ms. Duffy, but I appreciate the question.
Bridget Duffy from the Clark County District Attorney's Office. Assemblyman Trowbridge, I do appreciate that question, as that has been brought up to me in conversing with some of the opposition. This is not going to diminish the fact that we still have to have two grounds. We have to show that it is in the best interest of the child by clear and convincing evidence. That is a very high civil burden of proof because we are terminating a fundamental right. And we have to have parental fault. So we have to show both of those things. This is not changing that issue. I will also say that when approached by Senator Hammond to take a look at some potential language, I did do research. And the language in Section 3 was mirrored off of Massachusetts. New Mexico has similar. I mentioned them earlier. And not only did I look at their language, but I looked all the way up their case law to ensure that that language has been upheld in both of those states. I also believe that that question could be posed to your legal counsel because I know that they had addressed it as well on the Senate side.
Thank you very much.
Mr. Sprinkle.
Thank you, Mr. Chair. This kind of goes to two questions that I have. The first, those first 12 months, when a child is first removed, would you agree that the whole point of those 12 months is to try to work some sort of reunification plan so that they can get that child back to their family structure, their parents, if that's who it is, and that ultimately is what studies have shown is the best alternative for that child, right? Isn't that what these agencies are trying to work towards in those first 12 months?
Bridget Duffy from the District Attorney's Office, Assemblyman Sprinkle. Thank you for the question. Yes, those first 12 months, now with some exception if aggravated circumstances exist, we file those in 3% of the cases. And in fact, I think this committee heard some conversation on another bill about that before. So we do 3% of those cases, we may be able to succeed on a motion to not provide reasonable efforts. For about 97% of those other cases, the Department of Family Services or Division of Family Services throughout the state is providing those reasonable efforts.
Which is good. That was the answer I was looking for. Because my actual question then to the bill is under Section 1, subsection 2D. It's the new language that talks about has been responsible for the abuse of another child regardless of whether that person has successfully completed a plan for services that were recommended by the agency. Doesn't that kind of go counter to what we're trying to accomplish in those first 12 months? Because what we're trying to do is work with those parents, get them through a structured plan that the agencies agree is what they need to do, and ultimately trying to see if they can reunify that child. That, as you said, is the goal in those first 12 months, yet this seems to be completely counter to that.
Bridget Duffy from the Clark County District Attorney's Office. If Assemblyman Sprinkle, hopefully I'll be able to clarify this. Section 1 is one, not a termination of parental rights section.
Right.
It is specific findings of when a child is in need of protection and when a child may be in need of protection. And so what this bill does is it makes it mandatory that a child is in need of protection, and I am at Section 1(1)(c)(1) and 2. So a child is in need of protection if the child has died as a result of abuse or neglect, or has been subjected to abuse or neglect by that person, unless the person successfully completed a case plan. Completed the services that were recommended by the agency to address the abuse of the other child, and then if they have completed the case plan, it was still necessary to make sure there was some discretion for the court that child may still be in need of protection. So, for example, a baby comes into care and they're in the hospital, nothing has happened to that newborn. However, there's a 3-year-old sibling who's been in foster care for 3 years because they have been physically abused by their parents, and they have not reunified. So their case plan may not be completed depending on what the district court is saying. So at that point, that baby in the hospital would be mandatory in need of protection. because it is not safe for the 3-year-old to go home, as determined under court oversight. So the child in the hospital is more vulnerable. Now, for example, say that 3-year-old went home and a new child was born. And so we have that person had been responsible for the abuse of the other child, but they completed a case plan, so they're not mandatory in need of protection. But if they then physically abuse maybe a child that they're babysitting, despite the fact that they completed their case plan, that child now may be in need of protection. So it's giving the court the discretion even after they've completed the case plan, because there may be a whole nother reason why that child's in need of protection.
Well, okay, I think I followed you. I guess it seems to me that the courts would still be able to do that because they would still see other reasons that are already spelled out in statute to continue to remove that child. But I won't argue that point. I do think that kind of gives maybe parents potentially a false sense of hope that they're trying to work on something and this exists, that even if they get through everything, they might not be able to. But then, Mr. Chair, if I may have a separate question. Thank you. So then moving on to the next part, Section 3, when we're talking about the D and E, where we're talking about the strong positive attachment bonds with these substitute caregivers, I guess I'm a little confused here because foster care is not designed to be permanent, right? These are places where these children are being placed so that they're in a safe environment while they're working through those first 12 months in a permanency plan. But then once we get to a place where we're looking at termination of parental rights, ultimately, and please correct me if I'm wrong here, the goal is still not to have that child stay in foster care at that point. Even if those parental rights are terminated, then you're looking for some sort of permanent plan, i.e. adoption, which very well could be a family member. An example that was given to me is, or I could just use myself, hypothetically, that if I'm an uncle to a child that is removed in Las Vegas, I live in Reno, Oral Sparks, during those first 12 months, it's not feasible for me to then have that child on a daily basis because that goes against what you're trying to work for with reunification. Day 12 months and 1, if that child has now developed bonds with the foster care person, but now I suddenly am allowed to be in the picture and potentially adopt, I see this as counter to what we're trying to do, which is ultimately still place a child within their family structure, which, as far as I understand, is ultimately what we're always going to try to do, is keep a child within their family if it's safe and right for that child. So I'm not quite sure. I think I have issue with the fact that a foster agency, which isn't supposed to be permanent, potentially could be given more credence as far as where that child ultimately is going to end up than even other family members once that 12 months and 1 day period hits. Does that make sense? It was kind of convoluted. I'm sorry.
I am going to say it made sense. Assemblyman Sprinkle. Bridget Duffy from the Clark County District Attorney's Office. Ultimately, a couple things. One, if you are in Sparks and you want placement of your nephew or niece that is in Clark County, we have processes in place where we can have that child, if you are approved, which hypothetically I believe you would be, as a safe placement for that child, we could help get that child to you with the oversight then of the Washoe County area. Okay, so we can bridge that gap, and hopefully that gap will be bridged prior to 12 months, hopefully, because we're all one state. So that I think kind of addresses that issue. In the end, the best interest of the child is going to prevail on placement issues, as it should. And so when we have had, I've argued case law, I've had case law with the Nevada Supreme Court where we have had foster parents and relatives that have come out, and sometimes it's, a year after the child's in care, and the court says you have to look at not just the relationship, but you have to look at the best interest of the child and what would happen to that child. That's why we have a statute in place that says we need to exhaust our search for relatives within 1 year, because a 1 year mark is a pretty big deal. So we should be looking for relatives within 1 year. That's already embodied in statute, because we don't want children to start going into homes then have to be moved. because we find that relative that we prefer to place with. And the other part of that is, and kind of going back to some of your other questions, you know, most of our reunifications occur within the first 11 months. Most of them occur within the first 11 months because we aggressively, as we should be, trying to get those children home. It's when we can't do that, when we don't get there and the court changes that plan, we need to consider what's happened to that child while the parent, through their acts or omissions, have allowed this injury to occur.
Well, and I guess the only issue, and I appreciate that, and I understand what you're saying. I guess I'm stuck on the fact that foster care is not permanency. And these kids are in a very vulnerable state when they're first removed, and it's almost natural, and maybe the physician down south could address this. It's almost natural that they're going to develop bonds potentially very quickly with the people that are now providing them a safe and loving environment. I don't know if it's okay that we're now going to say that that sort of credibility should be given to determining a permanency plan for a child if parental rights are being taken when foster care is not permanent. Adoption's permanent, but not all foster caregivers are willing to adopt. And I guess that's the issue I have with this one section.
May I respond?
Please.
Yes. Bridget Duffy from the Clark County District Attorney's Office. I understand what you're saying. I absolutely do, and I appreciate this conversation. That is why I believe Section 3 has 5 specific considerations for the court. It's just not the one. It's consider those placement options so that we're considering the fact that there is an adoptive home. We're not, you know, the foster home that's not adopting is not a placement option for long-term permanency. That we consider that age of that child and the cognitive needs, and then the factors of which you have some issue, which is the strong positive attachments. So they're all to be considered, not just one. They are all to be considered. And foster care isn't permanent. And foster care isn't great. Foster care isn't the answer. We need something for our children that are being abused and neglected. And again, there comes a point where we have to make decisions on how long is long enough and focus on that child.
And if I could, Mr. Chair, Scott Hammond for the record, and I can't really add too much to what Ms. Duffy said, but again, I look back, and I'm glad she just followed up with your question, Ms. Assemblyman Sprinkle. But, you know, again, if you look at the language saying that it shall be a consideration, and in this case, the story that I gave in my remarks talked about a foster child who had been in the care of a family for over 4.5 years, or for just about 4.5 years, and so it was used as a consideration. And that family, of course, is willing to adopt that child. And so here's somebody who's grown attached to that family after a year and 1 day. I think the consideration would be similar to what you've already stated. You know, you were up in Reno or Sparks, and maybe you wanted to make sure that child stayed close to the school that they were used to, people they knew, and so you thought maybe they could find a solution within that 1 year, and then after that 1 year it just wasn't working out, and that's why you would like to be placed in consideration. And I think the courts would obviously, I would in my mind make that consideration. So again, I think it says shall consider these factors, and there's several new factors is all we're asking for.
Thank you, Mr. Sprinkle. Any other questions? Dr. Titus, and then Ms. Dickman. How's that? Because she's a doctor, she gets to go first.
Thank you, Mr. Chair. I appreciate it. I have some concerns along the same line that Assemblyman Sprinkle had, in that on Section 2, line D, the same thing, whether a child has formed a strong positive attachment or bond with a substitute caregiver. In my mind, in foster care, the purpose of finding a good match in foster care is that you hope that these children would form a bond. I mean, I think you don't want them to go into foster care where they're going to immediately not form a bond, and they're not going to feel safe, that they're not going to have an attachment, because children are very they need that. They want somebody to love them. And when they're in a loving, caring foster home, you want them to form a bond. You want them to form a bond in school and friends immediately. So that's the goal of foster placement, is to match that child, whether it be a relative or somebody in the foster system. So I'm a little anxious about using that as a determination, even a consideration, because if foster care is doing a good job, they're all going to form that bond. And so and I think to look at taking somebody's parental rights away based on the fact that this child who's just looking for love now has an attachment, I have real concerns about the parental rights on that one. Although I understand where the bill is going, and I am concerned about children also, that one I just have a hard time with.
Bridget Duffy from the Clark County District Attorney's Office. Again, Assemblywoman Titus, I do appreciate those comments. I appreciate this conversation. I would like to just focus on that, is why the 1-year mark is so important, and why when I tell you that we are getting children home quickly in 11 months, that's significant. Because we are aggressively getting kids home. Our reunifications are occurring in 11 months. It's after that 12 months where we hope, just as you said, that these children are forming healthy attachments, that we have to start considering the fact that length of time has occurred and what it would mean to that child, despite the fact that we have worked to get these children home to their parents.
Ms. Stigman?
Thank you, Mr. Chair. Help me understand or confirm whether or not I'm understanding the bill. Isn't kind of the point of it, there was talk of foster care isn't permanent, but until parental rights are terminated, a child can't be adopted, correct?
Bridget Duffy from the Clark County District Attorney's Office. That is correct. They can either voluntarily relinquish their parental rights, or we have to move to terminate their parental rights.
So if that's okay, Mr. Chair, if a child has been out of their parents' care for well over a year, isn't it time in the best interest of the child to look for something more permanent?
Bridget Duffy from the Clark County District Attorney's Office. Our statute currently mandates that if a child has been out of the home for 14 of 20 months, it is presumed to be in the best interest of that child to terminate parental rights. And it is also presumed that the permanency plan or the termination of parental rights should be filed. And that's state law. Federal law is 15 of 22 months.
Thank you.
Any other questions from the committee? Dr. Titus has a clarification, and Ms. Benitez Thompson.
And maybe you've already said this on the statistics, but I'm a little concerned that if that 12 months is due to court delays and those kind of problems, not necessarily the issues with the parents, is that taken into consideration? Because sometimes just filing, you mentioned how many cases you have and backlogs and how long it takes, and that you make every effort to push these through, but sometimes there's just a tremendous amount of court delays, and I would hate to see that's also a reason, because the courts could, because the process didn't happen in time, that now suddenly this child has an attachment to the foster parents, and now they get taken away from the parents. No fault really to parents. And I understand that if there hadn't been a fault initially, you wouldn't have taken the child away, but sometimes this happens before any adjudication, before any court decision that there really was fault, and now this child's out of the home.
Bridget Duffy from the Clark County District Attorney's Office. Children are out of the home because of abuse or neglect. That's why they are in the custody of a child welfare agency. The time frames that are discussed currently in statute are driven just by time frames. There should be a sense of urgency on our courts. There should be a sense of urgency on our parents. On our DAs, on our public defenders, on our children's attorneys, on our CASAs. Everybody should have that sense of urgency to get those children back home within 12 months. Are delays not in the control of a parent? Absolutely. Right? Court calendars, all of those things. But I believe that when making those determinations of parental fault, the court will consider that. Sometimes the courts give parents years and it's the benefit. The parent is getting the benefit of years of reasonable efforts, while their child is in a home through very important cognitive and developmental time periods. So it kind of works both ways. The parents can come in at 1 year and say, I just started a drug treatment program because now you've served me with a termination of parental rights. And now I know you're serious. So, and then the court will say, okay, I'll give you 3 more months, 6 more months, 12 more months. And at that same time, those children are still there. And that's why that age of that child is important, because it's a very different story for a 13-year-old than it is for a 2-year-old. And that consideration, I think, is something very important in this.
Mr. Moore.
Thank you, Mr. Chair. I support you on this 100%. I just need a little clarification. So a biological parent, there's some type of abuse that has gone on. The child is removed, placed into foster care. I'm just trying to get my own mind around why would the courts or whoever, why would they be even concerned with trying to put the child back in or rehabilitate the parent? You know what I mean? That just seems counterproductive, and they forfeited their right at that point, in my mind.
Bridget Duffy from the Clark County District Attorney's Office. Assemblyman Moore, I appreciate your views and your thoughts on this system. We do have a responsibility to keep families together and to make those efforts. I support those. I think we do. They're the parents, for better or worse, and we are there to help them get their kids back. I believe we, though, have to come to a point where we have provided everything we can. The parents have had those opportunities, and we need to focus mainly on that child. But I do respect where you're coming from, but I also do believe it's important to work with those parents when those children are first removed.
Any other?
Dr. Titus, go ahead.
No, I was just going to look for any other comments. Ms. Benitez Thompson.
Thank you so much. I guess I was going, and my apologies because I had to step out for a moment, but I was going back to what I believe it was psychiatrist was saying, that you had testify about permanency and the importance of permanency, and I still come back to looking at the child welfare system and thinking, how can we fix the system? Families are imperfect. A legal system is imperfect. Our child welfare system is imperfect. But how do we take steps forward in a meaningful way? And I still think that if we say that we are going to set a standard by which we're considering the child's best needs, then we really should make that apply across the board. And why not penalize child welfare systems for the number of foster care moves that they have? For me, when a foster care placement fails, it means that they're not getting enough support services from the agency to support a child in that home. We know that our children with special needs have the highest disruption rates. So why not require the counties to pay a higher rate for those children with those needs and then wrap more services around them? I can't imagine a foster parent that would say no to additional services and support. We know we're not working with a perfect system, so as opposed to holding biological parents accountable for these imperfect systems that they come into, that they ought to be brought into, why not take a more critical look at the flow and the process? And I know you talked about imperfections with the judicial system and the courts, but that's you, right? That's your department as a district attorney. If cases are going on for 4 years, there's a problem there. And that problem is going to be with the system that's supposed to be taking care of this child. So what's happening in the courts that a case is going on for 4 years?
Bridget Duffy from the District Attorney's Office. Assemblywoman Benitez Thompson, I appreciate the question. There's a lot going on. We have, in Clark County, we have high case numbers. We have 3 judges, 3 hearing masters. We have hearing masters that can't hear the same types of cases that judges hear. So we have attorneys with high caseloads that are stretched between 6 courtrooms. We have all of those things. I think everybody that works in that system is there because they care about families, or they care about kids, or they care about both, as I like to think I do. So I believe that the Department of Family Services will be speaking later, but I will tell you, as far as your concerns regarding foster parents and holding them accountable and supporting them in Clark County within the last few years, we have started something called the Quality Parenting Initiative, which has it's a way of bringing foster parents and the agency together to find out how can we support foster parents to do such things as, stop these disruptions. And again, I'm not an expert on that at all, and that would be an agency question, and I will defer to the agency. Hopefully she will be able to answer it when she gets to the table. But we are working on that. So it's a positive thing.
Thank you. And then could you tell me, does the statute not contemplate a child's attachment to foster parents when you're considering adoption? If I'm right, we have such a statute that contemplates child's best interest in terms of placement already. Isn't that correct?
Bridget Duffy from the Clark County District Attorney's Office. Yes. As I was answering Assemblyman Trowbridge's question, we have to prove 2 things. We have to prove best interest, and that's the primary consideration, and then we have to prove parental fault. Currently, within our termination of parental rights statute, there are considerations of best interest, and the love, affection, and emotional ties between the child and the foster parent and the child and the biological parent are considered. The morals of the foster parent versus the morals of the parent are considered. All of those things are considerations toward best interest. This is a consideration toward parental fault. And that is, again, we would not be the only state who has that type of law. Other states have considered just basically the length of time a child has been in care as parental fault.
Go ahead.
And some of these questions might be more appropriate for some of the agencies. So, and I know they're going to come up to testify, so please let me know. But I was going to ask about the number of children that we currently have waiting for adoption that are legal orphans, and I might be able to guess what some of those numbers are by the different child welfare regions. But do you have an idea of how many children right now that we need adoptive homes for?
Bridget Duffy from the District Attorney's Office. I would like to defer that question.
Makes sense.
I was trying to get that answered, and I was not able to get any emails today that helped me answer that question for you, but perhaps somebody else that's coming up may have that answer.
And I see some department heads here, and I bet they know those numbers like the back of their hand. So I'll save my my questions for them, Vice Chair.
Okay, if there's no other questions right now for the sponsor and the major presenter, I think what we'll do is go ahead and open it up to testimony in favor of SB 303. And because of the timing, and it's important to hear both sides, for and against, I'm going to allow 15 minutes for testimony in favor, and then we'll allow 15 minutes for testimony against. So I'd appreciate if you keep your comments brief, although I understand that this is a very important issue. So identify yourselves and go forward. And we'll start in Northern Nevada with the people currently at the table, and then I'm going to go down to Las Vegas.
My name is James Smith. Thank you so much. It's a huge honor to be speaking in front of you all today. I've been a foster parent. In September, it'll be 9 years. In that time, we've reunified 5 kiddos. We've done 4 special needs adoptions through the Department of Family Services. And the story you heard earlier, for the last 5 years, Emma has called me Daddy. It has been a roller coaster ride of emotions. Watching from the beginning to where we are sitting right now. When we said yes to that phone call 5 years ago, I'd never imagined I'd be sitting in front of you guys right now. We were told about a young couple that just needed some help, just kind of needed to see, how life was, and we came along this couple, and we helped. And I stood in parking lots and prayed with them as they lost loved ones after TPR trials and then getting it continued for 2-3 weeks, which is really difficult when you have all the emotion of that building up. And then the judge looks at the calendar and says, well, we can't reconvene until 3 weeks later in September. And you're sitting in the parking lot with them and you're just talking and you're saying it's going to be okay. We'll figure this out. For 3.5 years, 4 years, we supported them. Unfortunately, things kind of get messed up in the system, and we've seen the relationship deteriorate a little bit. We're still there and we're still open to support them, but I'm here today as a dad. I've got 5 kiddos at home, 436 miles away from where we sit right now. Emma's probably wrestling with one of her brothers or telling her sister what to do and how to clean up their room. She is a spitfire little diva, and she's enjoying life. The thought of her being treated like a case file has been probably the biggest heartbreak for us. When we walk into court, it's motions this, it's we want to do that. When can we get the next hearing on the docket? It's not, hey, how's the child doing? You guys have a very awesome opportunity to be a voice for the kids in our state. I've gotten phone calls from foster parents across the country because of what's going on in support, and they're watching. And I have communicated with several of you. I've had family members communicate with several of you, and I thank you for your response to them. I thank you for the time. And I'm just so appreciative that we can even have this moment, that a little girl that's 5.5, that has no idea. She thinks you guys are judges, by the way. She thinks Daddy went up to talk to judges today. She's so precious. But you know what? I don't want this to happen to somebody else again. I don't want another little boy or a little girl that comes into our system that's been a victim of something atrocious that we can't even think of in our worst nightmares, or we don't want to think of. I don't want them to be victimized again, that the system has to take so long. So I just want what's in the best interest of the child, not my desires, not the DA's desires, not the parents' desires. I just want somebody to step back and say, this is in the best interest of the child, and this is what we need to do. And that's going to go both ways. That's going to be reunification. That's going to be adoption. That's going to be new case plans for parents. That's going to be helping hold foster parents accountable. But I'm asking you today to think of what 5 years is. Think where you were 5 years ago. I realize that's what Emma's been doing for the last 5 years. And she's a sweet little girl, and I know there's little boys and little girls just like her that are waiting on your wisdom and your decision. Thank you for taking the time to listen to me. I'm very, very grateful for this opportunity.
Well, thank you for your testimony, and thank you for caring for Emma and just being there at the right moment and sharing your story with us has huge impact. Go ahead.
Thank you, and thank you so much for your testimony, and thank you for being a dedicated foster parent. And so with the child that you've had for the 5 years for this particular one, Emma, do you feel like you've gotten all the support necessary as a foster parent from your foster care agency to support her in your home? I'm not sure. Are you? I know you said she's at home. I don't know if you're from the rurals or from up north.
I'm Las Vegas.
Okay.
So.
And so do you feel like you've gotten all the support that you've needed in order to create a good home environment for her?
I do. I feel like there's services there, and to expand a little bit, 4 special needs adoptions have come through my door, and they have really bent over backwards to help us. Now, foster parents aren't perfect, the system's not perfect. So there's bumps, but when stuff comes up, they really help us and bend over backwards.
And I guess a follow-up, I'm glad to hear that, because happy foster parents make for happy foster kids. And over the course of your time being a foster parent, so especially like with your special needs kids, you felt like services have been in place to help them, emotional, therapeutic. You felt like you've been supported as a foster parent. Have you ever wondered why the case has gone on and been open so long? I know you talked about the judicial problems, and there's definitely the courts are so busy and backlogged. But do you have an idea of why that case has been open for so long? And you don't have to give technical stuff about the case. I guess I'm a general feeling.
There's a purpose for everything, and I'm not sure I see the purpose in this yet. But I can tell you that anything and everything crazy that could happen to this case has happened. We had a judge, the original judge, is in trouble with the feds. So I mean, I am telling you, this has really been a roller coaster and an up and down and a back and forth. And it just seems like when anything can come to kind of stall things out, it happens. I mean, a year waiting on the Nevada Supreme Court. We're still waiting on the Nevada Supreme Court. So I mean, it just seems like there's time to us as adults is different. Time to kids, I mean, she's almost 6. That's a third of her childhood. That's a third of her being, underage. To us, a day is a day. To her, those days leading up to Christmas or her birthday is an eternity. So for her, it's like she's been there for all her life.
Okay, thank you. We'll go to the next testimony.
Thank you for hearing my testimony today. Excuse me. For the record, my name is Daniel Rose. I'm a resident of Logandale in Nevada. It's just outside of Las Vegas. I, like JD, have come far to be up here to testify. I am missing coaching 2 of my son's baseball game tonight, and they fully understand that Dad is going up there to help their brother. So I'm going to try to stick to my script because this is very difficult, because what I say or don't say, what you do or don't do, greatly not only affects my family and my future son, because right now he's my foster son, but I call him my son, and other families across Nevada that have the same story that I have. My wife and I have been foster parents for 11 years. When we began, it was to provide a safe, healthy environment for children in need while their birth parents corrected the issues that caused the child to be removed from their home. We loved each and every child under our care. However, there are times that the Department of Family Services begins to look for adoptive resources for children in their system. We have been blessed to adopt 5 children. All children placed in our home were infants at the time. Currently, they are now 10, 10, 8, 7, and 5. There's no difference in the love that we have for our adopted children than we have for our natural children, and we have 5 additional children above that. So our house is very loud, very noisy, and very busy, and very diverse. Every one of our kids in our family look extremely different. I tell everybody I would adopt a plaid child if they made one, but it is what it is. Okay? We have begun the adoptive process of our 2-year-old son. He was born on February 18, 2013 at UMC Hospital in Las Vegas, Nevada. We picked him up 5 days later, and he's been part of our family ever since. Unfortunately, his birth mother tested positive for drug use, and her baby was exposed to drugs. During the first year of his birth, we were up most nights due to sensory overload issues and his difficulty sleeping. He began receiving occupational and physical therapy treatments from Nevada Early Intervention once a month. At the end of March in 2014, he woke up and was unable to stand or walk, and he was walking fairly well at that time. We took him to our family doctor, a pediatrician, and they were unable to diagnose his condition. My wife spent hours and hours on the internet trying to find out what was wrong. He was having difficulty walking and just wanted to be held. He was in quite a bit of pain. We had experience with our 25-year-old daughter who was diagnosed with rickets at a very young age with treatment by Dr. Tyerman at Shriners Hospital in Los Angeles. So we made an appointment to see Dr. Tyerman. After several tests and exams, he was diagnosed with RF-negative polyarticular juvenile idiopathic arthritis, or JIA. It is an autoimmune condition that results in inflammation of joints. JIA can also attack the body's organs and eyes. This disease can not only cripple, but can cause blindness and death. Currently, he is undergoing treatment, which includes weekly injections of a chemo, Enbrel, which also treats arthritis, twice daily liquid medication for inflammation, daily eye drops for inflammation of his eyes, along with daily supplements because the drugs that he takes affects his appetite and gives him mood swings. He has physical and occupational therapy once a week, which we drive up to St. George, Utah to get that condition or get that care for him, and see his specialist for his eyes once a month, sometimes twice a month if he has excessive redness. He's also been recently diagnosed with hypermobility, which is causing a lot of his night pains. It takes roughly 2 hours for me to massage him at night to get him to go to sleep, and that's each and every night. He's being fitted for leg braces that will help him walk and require him to wear in bed for his leg pains. Without the treatment, children with arthritis run the risk of serious complications and disability. There is no cure for this disease, only treatment. Often over time, medication may no longer work, and a change in medication is needed. Sometimes the treatment may cause joint injections or replacement, so badly damaged from this arthritis. He has shown improvement due to the medication and treatment and the fact that we've always followed through with his treatment, medication, and provide a loving, nurturing home. He's surrounded by his brothers and sisters who love him dearly. His birth mother left shortly after his birth, but now after 2 years, his birth father has been released from prison and wants placement. We are the only family this boy knows. His older brothers and sisters have bonded with him and him with them. We include him in everything we do. He is always with us. We have never had a babysitter outside of our family. He has never been with anybody other than us. The Department of Family Services and the courts have always considered that placement in our home continues to be in the best interest of the child. But the birth father was only present for the conception, may not be able to provide for long-term care provided, may be given custody. Not only not be able to provide for the care, but now he's currently saying that he does not have arthritis. He will not treat this child for arthritis, and he doesn't care what the doctors say. So now this could be a death sentence for this child if he's sent back to his home. Those of you that are parents, when your child is in pain and they hurt, all they want is mom and dad. We are his mom and dad. He trusts us to take care of him. It saddens us to think that removal from our home would cause a setback in his treatment and be detrimental to his physical progress, not to mention his emotional needs. We're not the only family that has found themselves in this heartbreaking situation. I am sure that many more families will be faced with the removal of their child in their custody for long term. The main consideration should always be the best interest of the children. I heard a lot of discussion today about family. My family, like I said, is 11 kids. Some have my blood, some don't have my blood. They're my children. I'm their father. My wife is their mother. There is no different. Blood does not make family. Love, caring, nurturing makes family. So please, I urge you to consider this bill and pass it into law as soon as possible for those families like JD, myself, and other families that are going through this. Thank you.
Thank you. Thank you for your passion. Thank you for your love and all those little children at the house that call you Dad. Go ahead, Victor.
Thank you, Madam Vice Chair. My name is Victor Jakes. I'm here today in my personal capacity. My wife and I are licensed foster parents in Clark County, and we support AB 303. As foster parents, we understand that the best interest of a child is paramount, and that when we first get a child, the first goal is reunification with the natural parents. When reunification doesn't occur, however, and shows no signs of occurring, that goal of permanency begins to move from natural parents to adopt an adoptive resource. And I just want to explain, when you talk about, there's a case plan and you have a child and you haven't seen, you go to visits and the natural parents don't come for weeks or for months. This bill does not address situations where the natural parents are working their case plan, they're doing their classes, they're coming to visits. What this is addressing is, natural parents who haven't seen their kids in years. So I don't want anyone to think this is an often occurrence. I mean, this is a very rare thing. And we support allowing the best interests of the child to include the factors listed in SB 303. The language is not a mandate for a specific decision to be made, which is important, but it simply forces the court to consider the additional needs of the child. Thank you.
Thank you. We'll go down to Las Vegas now for testimony in favor of SB 303.
Hello. We're a little concerned about the 15-minute time limit. We sat here for a long time and we noticed that the other bill got 30 minutes, and so we respectfully ask if our side can have 30 minutes and if the opposition can also have 30 minutes as well.
Right, I see that also. We have decided to move and delay the hearing on SB 88 and SB 148 so we can have some more time. And as long as they don't shut you off in Las Vegas, we will go ahead and go forward.
Thank you very, very much for not yelling at me. I will keep it brief. My name is Melinda Munson. I'm a resident of Clark County, and I'm a foster mom. We have had our foster children for 1 year, a 2-year-old girl and her sibling, a 3-year-old boy. They were removed from their home because of severe neglect. The house was filthy. They were not being fed. They were being kept in cribs all day long, and there was little interaction. Before they were removed, a nurse came into the home and tried to work with birth mom and tried to teach her how to appropriately care for the children. This was not successful, and they were put into the care of CPS. Birth mother has mental retardation. She cannot care for herself. She has a hard time having conversations, and she has difficulty with everyday living skills. After about a 6-month transition period, which was very difficult for us and for our foster kids blossomed. They've learned skills like pointing, talking, running, pretend playing, things they already should have been doing but weren't because of the neglect. They still struggle with emotional issues. Our 3-year-old son refuses to eat food. He has a temper tantrum about every 5 to 10 minutes throughout the day. He refuses to poop. His sister every night will cry for 1 hour and chew on her wood crib. Due to judge's order, DFS is currently looking for a company that would come into a private home and care for birth mom and the children as well. No one can say how much this program will cost or what qualifications the caregivers will possess. All of our foster kids' doctors and early intervention workers agree that this plan would be confusing and unhealthy for their emotional and cognitive development. If our foster children are reunited with birth mom, it would be their 4th placement in 2 years. Keep in mind they're 2 and 3, so they've been in care for a majority of their short lives. We've tried for over a year to help birth mom improve her parenting skills. Early intervention started doing sessions weekly with her and the kids to try and teach her these skills, and she was present but was unable to work on those skills, so early intervention asked her to no longer participate in the sessions. We offered to keep the children in our home for an additional 6 months so mom could work on her own living skills before she had to start taking care of the children, and that offer was declined. We offered to adopt the children and have an open adoption so mom could be involved with the children, and that offer was declined. In August, my foster kids will have been in care for 2 years. Should our foster children be reunited with birth mom, and should that placement fail, I am concerned that we would not be available to take them back into our home. Right now we're managing their behaviors and things are okay. But were they to go to mom and have regression and come back to us, I just don't know if our family could withstand that stress. This breaks my heart because I know that Child Haven is full and there just aren't enough foster parents to go around. There are approximately 5 other foster families in Clark County who are in the same situation where mom has mental retardation or something similar and is not able to care for herself. And the judges have ordered those families and CPS to find group homes and companies willing to help raise these children. So I am a good foster parent. I have experience in neglect and I have experience with special needs. I want to help the children of Clark County. However, I can't be part of a system that protects birth parent rights above the well-being of vulnerable children. If laws and practices don't change, this will be our last placement. Please pass SB 303 so that our foster children have a chance to live successful lives. Help us end the cycle of multi-generational foster care use. And I believe Ollie wants to address us next. Thank you.
Thank you for your testimony. Go ahead in Las Vegas. Testimony in favor.
Members of the committee, my name is Ollie Hernandez, and I am testifying in support of SB 303. As an alumna of Clark County's foster care system, I have firsthand.
Can you? I'm sorry. I'm sorry. We can't hear you up here. Can you get a little closer? Speak up a little louder and re-identify yourself. There you go. Be forceful. You're passionate.
Hello? Anything?
Perfect. That's better.
Okay. Cool. Great. So, my name is Ollie Hernandez, and I'm testifying in support of Senate Bill 303. As a alumna of Clark County's foster care system, I have firsthand experience of what it is like to leave a loving foster home, be placed back with my biological family, and be put back into foster care because my family felt that they did not want to take care of my sisters and I anymore. In result of my experiences, this bill resonates with me because even though a piece of legislation did not exist while I was in care, I hope that along with my testimony, as well as others, that this will allow the bill to be made into a law in order to provide protection and ensure that foster kids in the system are able to achieve permanency with a loving foster family and receive protection. It is a rare occurrence for a foster kid to be placed in a home that treats them as one of their own. Once this happens, it has been found that the foster youth will form an emotional attachment to their foster parents. With all of the inevitable trauma and frustration that a foster youth endures, receiving love and understanding from a foster parent can heal those wounds and is found to be a godsend in some cases. However, to remove a child from what may be the only safe and loving home that they've ever experienced would be an injustice. It is understandable that everyone deserves a second chance. Although reunification is ideal, placing a child back with their biological family might be detrimental. Once a child is placed with a loving foster family, they are able to make strides to overcome any psychological or emotional trauma that they have endured. Placing them back with their biological family would backpedal any healing that they have made. In summation, while permanency and reunification are in-game, in some cases, the termination of parental rights may be in the child's best interest. Thank you.
And thank you. Just for time check, we started this hearing on the 4s at 4:14, and so we are going to give it the half an hour, but we're running close to that. So we'll take 2 more testimonies in Las Vegas and then come back up here to Northern Nevada in favor.
Good afternoon. Are you able to hear me?
Just barely. Get a little closer, a little louder.
I'm so close, I think I'm going to eat this thing.
Actually, that's perfect. We can hear you now.
Okay. Okay. Little uncomfortable, but we'll get through this. My name is Jennifer Barowitz, and I work for the Department of Family Services. I am a permanency supervisor. I have been with the Department of Family Services for a little over 12 years, and I've been a supervisor for 9 of those years. In addition to that, I've also been a foster parent, and I have adopted 2 special needs children. While I would love to sit here and discuss my family with you, I'd like to take the time to actually discuss another child. My children are safe. My children had their best interests served. But I'd like to discuss with you a child today who is actually the brother of Emma, who we've heard about earlier today. In October of 2014, the Supreme Court came down with a decision that I was to place, me being the Department of Family Services, Emma's brother back into the home of his biological parents. He had been out of the home for 1 day shy of his year birthday. Please keep in mind it was determined that Emma was not able to return home. Emma was in the process of going through the termination of parental rights hearing and was deemed not safe to return home. However, I was instructed to put her 1-year-old brother home. My job at the Department of Family Services is to keep children safe. I can't tell you that he's safe. What I can tell you is that the moment he left my hands, he also left my eyes. He also left the eyes of the courts. I can't tell you that he is safe today. I cannot tell you anything about his best interest, nor can I speak to his well-being. Nor can I tell you what his home life is like today. I can't tell you if the child is alive. One thing I can assure you is that there is a 3rd sibling on the way. It is out of our control, and we cannot do anything to protect that child. There were decisions made for a reason for Emma not being able to return home due to the severe abuse and neglect that she suffered, which to this day remains unexplained. How the best interest of her brother wasn't deemed important by the Supreme Court, I can't speak to that. I ask you today, and I know that I must keep this brief, so I will cut this short, but I ask you today to please understand, please make the right decision. Best interest of children has got to be taken into consideration, because when it's not, nobody can let you know if these children are really okay. Thank you.
Thank you. One more. We have a question up here.
Thank you, Madam Vice Chair. I just do have one question. You've identified yourself as an employee for Clark County Social Services. Are you saying on the record that this is the position of your department?
I'm with Clark County Department of Family Services, and absolutely it is.
Thank you.
Thank you. One more testimony in Las Vegas.
Thank you, Madam Vice Chairman and members of the committee. I am Rabbi Craig Rosenstein. I'm the spiritual leader of Temple Bet Emet here in Las Vegas, a past president of the Clark County Foster and Adoptive Parent Association, and a current board member of Fostering Southern Nevada, a nonprofit and non-membership-based organization that provides resources, information, and recruitment help to the over 3,500 strong foster child community in Clark County. And this wonderful lady that sits next to me is my wife, Audrey. She is currently the president of Fostering Southern Nevada and the manager of Peggy's Attic, the donations cottage for the Clark County Department of Family Services located at Child Haven. As the manager, Audrey services over 300 children and families in some form of protective custody in Clark County each month. In addition to our work within the foster care community, we are ourselves foster parents. We have fostered some 30 children over the past 12 years, have adopted 7 of them, and currently are fostering 2, a little boy 19 months old and a 13-month-old little girl, and we will, if asked, adopt both of them. Additionally, we have 5 biological children as well. We are currently, this little boy that we are fostering, we took home from the hospital and had him for about 4 months before he was returned to his mother. His mother had him for about 6 weeks before she called Child Protective Services saying that she could no longer take care of him, and he was returned to us. His mother then has not seen him in over a year. The putative father in this case, who has consistently refused to take a paternity test and who has never seen his child, came to court to contest the TPR at 16 months. We believe the court should have absolutely considered the best interests of the child in determining that at the time had gone on too long for the court to reasonably expect any form of attachment between the child and biological parents. This little boy now calls us Mama and Daddy and has 10 other siblings in the house to consider as his family. Yet the court took the matter off calendar and scheduled a trial for May. So I pose this question to the committee. Is it in the best interest of this little boy to be awarded back to a mother and a father who show absolutely no interest in him? And it's not an isolated story, neither to us or to all of the members of the foster care community. Audrey and I had one other foster children's case take nearly 2.5 years to complete. It involved a biological mother who had 8 prior terminations. The case included a termination of parental rights hearing, a trial then to contest that termination, and an appeal to the Nevada Supreme Court that took over a year alone to be resolved. If the court had ordered a reunification at that point, how would that have been in our child's best interest? She had been with us since she was 1 month old. Audrey and I, in our work in the foster care community, hear stories like this every day. On average, cases that are supposed to be disposed of through either reunification or termination in 18 months are taking over 2.5 years to complete. In 5 of the 7 of our eventual adoptions, we took these children into our home within 1 month of their being born. It was us who rocked them to sleep, got up in the middle of the night to feed them, took them to the doctor when they were sick, taught them their first words, enrolled them in preschool, took them for interventions as they were all drug and alcohol exposed at birth. We comforted them when crying and afraid, laughed and played with them when they're having fun. I can safely say that nearly all other foster parents of those over 3,500 children in the county can tell you similar stories. You've already mentioned some of the opposition that'll be coming forth in testimony later from this bill, and the one that really strikes me is the comment from many that this is a civil death penalty on behalf of biological parents. So I make 2 observations. Number 1, if this is so important to the biological parents that they consider this a civil death penalty, please answer me as to why when we had testimony before the Senate committee on this, not one biological parent showed up either in Carson City or in Las Vegas to testify in opposition to the bill. And as far as I know, there are no parents here as well today to testify in opposition to that bill. Also, it's curious that they link this as a civil death penalty, much as the death penalty cases in criminal cases. Public opposition across the country is opposed to the death penalty more often than not because those cases take upwards of 20 years to be completed before execution finally takes place or a stay or whatever takes place. So, in fact, it's the biological parents, basically, that are creating the civil death penalty by not working their case plans, by not being involved. And that's why these cases, we believe, take way more time than they are supposed to. In the 30 children that we fostered, 80% of them we've returned back to their parents, and very often in just in 2 or 3 months. As was stated earlier, they're active, they work their case plans, they make their visits, we become involved, we mentor them. I even did a baby naming for one family who was not Jewish but was so intrigued when I explained what the child's name meant in Judaism and in Hebrew that they absolutely insisted that he be conferred that name, and we went ahead and did it. So it is that 20% who do not work their case plans and take these cases way longer than they should be. And the court, up until this bill was being brought before this committee, has not had the discretion to simply say enough is enough. The impact then of Senate Bill 303 will be to remove that two-pronged test that's been brought up earlier and place the responsibility of keeping children safe where it belongs, with the children's parents. If the parents fail in that responsibility by any finding of the proposed statute's language, the court will then be able to consider termination if it is in the best interest of the child. The length of time the case is taken being a primary consideration in determining ultimate placement. So we urge you to support the swift passage of SB 303 and to urge your colleagues in the full assembly to do the same. Thank you for allowing us to testify today, and if you have any questions, both Audrey and I would be happy to answer them.
Again, thank you for your testimony, and the resounding theme is that you are all passionate folks who have given and dedicated your lives to these kids, and we thank you as a society, and I thank you individually. Now, however, I am going way past the 30 minutes that I allotted, but I'm going to come up here to Northern Nevada and take testimony against SB 303.
Thank you, and for the record, Madam Vice Chair, John Sasser, representing Washington Legal Services and the Legal Aid Center of Southern Nevada. May I have some clarification on how much time you'll be offering to the opposition? There's a number of people that have been waiting all day.
I'm going to give the same 30 minutes, and Las Vegas will stay on board. So,
thank you, Madam Vice Chair. Again, John Sasser for the record, and to my left is Steve Dahl, who is an ex-judge and attorney with the Children's Advocacy Project in Las Vegas for the Legal Aid Center of Southern Nevada. I will briefly outline our opposition to the bill, and then in the sections of the bill that we have trouble with, and then with the chair's permission, I'd ask Judge Dahl to talk a little bit about the sort of on-the-ground implications of this bill, and then we both be delighted to take any questions if the chair so permits. Very briefly, it's very difficult for all of us, I think, listening to the passionate testimony of the wonderful foster parents that we've heard today. We in the system represent the kids. We don't represent the state. We don't represent the parents. We represent what the kids come to us and ask us to do for them. So we're kind of unique in that situation. Sometimes the kids want to be with their parents, and sometimes they don't. So we see both sides of this coin. Unfortunately, however, the way I read the bill, the concerns of none of the folks you heard today, if this bill had been law 5 years ago, would have changed anything. Their circumstances, to me, fall into several categories. Either they are arguing that these factors, the new factors in the bill, should be considered by the court in looking at the best interest of the child, and we have no objection to that whatsoever. In fact, we'd be happy and as the gentleman to the right is proposing an amendment to do that. So in considering the best interest of the child, the bonding with the foster parents and all those things are perfectly legitimate considerations. In fact, they already exist in the law. As Ms. Duffy mentioned, in 108, it goes through the court in looking at the best interest of the child to walk through if there's a prospective adoptive parent, what bonding there's been with that adoptive parent, what bonding there's been with the natural parent, what each home can offer. So that's already in the law today in the best interest of the child. What we have a concern with, as Ms. Duffy acknowledged, is they are not satisfied with that current law. They want to take these factors and put them in another place in the statute, the place in the statute in which the court is deciding whether or not there's been parental fault. Mr. Throbichard asked the question, isn't it true that you have to meet two tests in order to terminate parental rights? And Ms. Duffy acknowledged, yes, you have to show both parental fault and you have to show best interest of the child. So what is happening here is this would be one of the factors that a court would be asked to look at in considering whether the parents are at fault. What their age is, whether they've bonded with the foster parent, that has nothing to do with the parent or their conduct. So that is our concern, is you're taking something that should very much be legitimately considered in looking at the best interest of the child, but putting it into parental fault. The second part of and that's in Section 3, the second part of the bill that gives us heartburn is the part of the bill that deals with if you have, under today's law, there are two sections in Section 1, what things are considered automatically to be showing the child is needing services and what may be. They have taken abuse of another child, moved it from the may be considered up into the it is, it does show the need for protection. So it's from a court can do it to a court must do it. And they do this when there is a second child, for example, born. If there had been 5 years ago an abuse of a different child, then automatically the court must find that this child is needing services because of something that may have happened at a remote place in time. That goes completely contrary to the recommendations of the Clark County Blue Ribbon for Kids Commission, and Judge Stahl has attached some excerpts of that for your consideration. What that commission says is this, and I will read this quote and then turn it over to Judge Stahl with the chair's permission. Families are the cornerstone of our society, and the children have the right to grow up with their families as long as they can be safe. Removal of a child from a home should occur only as a last resort. Removing a child from a home, even if there is an imminent safety threat, is a life-altering experience for all those involved. Once removed, a child may be placed with an adult and other children they do not know, who do not look like them, who do not speak their language or follow their family's customs. They may be separated from school activities and as adults they trust. Removing a child from a home is a monumental decision and should not be made lightly or quickly. Every child should be who should be in care must be in care, but not one child more. The Commission recommends that reasonable efforts decision-making of both the Child Welfare Agency and the court be fully examined. Clark County needs to ensure that removals occur only when children cannot remain safely in the home, that in-home services and the use of voluntary service plans with judicial oversight are used to avoid removals when safe and when removals are necessary, and that relatives are identified and used as preferred placements. So this bill takes out of the court's consideration any consideration of imminent harm to the child, but says it's an automatic determination the child needs services and will be removed if there has been past abuse of another child. So we think that runs the risk of bonding with foster parents when the child might have been in their home. So we appreciate all those foster parents. We appreciate the concerns they raise and the concerns with the system. There are lots of recommendations in here of how to deal with the system. Not one of those recommendations states you should lower the standards that the DA must prove when they go to court, either to terminate parental rights or to find that a child is needing services. And Judge Dahl can sort of talk about how this plays out on the ground with the chair's permission.
Any questions before we go on? Assemblyman Moore?
Thank you, Madam Vice Chair. I'll be very respectful of my question here. You touched on something that I just would like a little clarification. So in your testimony just now, you stated that you have an issue with the fact that there, in your words, could have been a prior abuse of a prior child in a remote place and time. So is it your testimony that you don't find that as an automatic disqualifying factor or a factor for another child to be removed? Is that what?
Pardon me, for the record, Madam Vice Chair, John Sasser, in response to Assemblyman Moore's question. Today, the court may find that child in need in services. It is my testimony that I don't think should be an automatic. The court's hand is tied that child must be removed if that child is not under imminent danger or threat of danger, as the Clark County Commission recommended. Yes, that's my testimony.
Thank you. I will just say that I will agree to disagree, but I find that a very vile answer. Thank you.
Assemblyman Trowbridge.
Thank you, Madam Chair. You mentioned the term voluntary parental services plan, something to that effect, where it sounded like they were looking for a company that would come in and help a parent that wasn't up to the task, train them. Maybe it was about another case. Could somebody tell me about that plan and what the qualifications are to receive that type of assistance and who pays for it in the face of free foster parents?
I think Judge Dahl might be better equipped to answer that in Clark County. But yes, it's rather than removing the child and starting to place them with strangers or take them to a safe shelter, an alternative the court might have would be in-home services while the court supervises, and there are people that provide those, and perhaps Judge Dahl wants to add.
And who pays and what are the qualifications to have that type of assistance, and who provides that type of assistance?
Steve Dahl, for the record. I'll introduce myself in a second. In answer to your question, for example, we have Boys Town, which is an organization that comes in and offers in-home services where they help parents learn how to be parents. They come into the home, give instructions to the parents on what they need to do to be better parents, how they can have a better home. And Boys Town will come in, spend several weeks with the family or longer, and eventually they'll essentially pass the family and say that they've completed those services and now they're better parents than they were before. And there's other agencies that do that in Clark County. They come in and provide what we call in-home services.
Is there a fee for that?
Usually not.
Thank you.
So Steve Dahl, I'm an attorney with the Legal Aid Center of Southern Nevada. I work for the Children's Attorneys Project. As attorneys of the Children's Attorneys Project, we represent individual children in individual cases. And one thing we've learned is that each child is different, each parent is different, each foster parent is different, every fact situation is different. There is no one size fits all. And you cannot legislate yourself around every problem. Each case has to be dealt with individually. Sometimes I just close a case that was a little more than 2 years old, and partly because that's what my client wanted. He wanted to go home, and it took us that long, and he was just as happy as he could be when he went home to live with his mother for the next 5 years. We do what our clients ask us to do. Sometimes the courts say yes, sometimes the courts say no, but that's what we're trying to do. No one is saying the cases that take 5 years to resolve are a good thing. That's bad for everyone. It's bad for the natural parents, foster parents, especially bad for the child. It doesn't reflect well on the system. And I don't want to argue facts, because a 5-year-old case doesn't matter so much what the facts are, it's just bad. But I will tell you that the Supreme Court gives a much different version of the facts than Senator Hammond gave you today as to what happened, and puts fault in a different way than it did. And essentially the arguments being made today is that because a hearing master, Department of Family Services, the DA's office, and a district court judge made incorrect decisions and it took a long time, the parents should lose their kids because of the passage of time. They had worked their case plan. There was a hearing where they were discussing reunification, and it went sideways from there. And all the delays after that, the Supreme Court said, weren't the parents' fault. But the argument being made today with this passage of time kind of thing is, well, too bad. It's been a long time. They don't get their kids back anymore. And that's just, well, it's not legally right for one thing, but it's just not right. You've been hearing stories on one side, which they say, and it was said that this wasn't to make adoptions easier, quicker, whatever. That's a little bit disingenuous to bring all these people in to testify, present a statute, and then say it doesn't make it quicker or easier for people to adopt. And you've heard stories from people that on the one side would say, yeah, we ought to do that. Well, there's a lot of stories from the other side. And I didn't bring my clients to testify, but I'll tell you about one of my clients named Oliver. Oliver and his sisters, when Oliver was about kindergarten age, were removed from their family, removed from their mother. And a while later, they were adopted by a family. Everyone thought they were just swell. Nice family, other kids, lots of support. They did the adoption, moved up to Utah. A couple years later, Oliver developed some problems. The family decided they didn't want him anymore. So they put Oliver in a car and brought him down and dropped him off with the mother whose rights had been terminated, and went back to Utah where the two sisters are. They didn't tell anyone about that. We didn't find out about Oliver being back until his dad popped him around a little bit, and he came back into the system. That is just, what could be worse for a child than something like that? And adoption givebacks, that's what I call them, are a real problem that we face. I have 3 right now where children who were adopted, the parents decided, oh, there's something wrong here, and they're trying to give the kids back. We have cases where kids get into the adoption process, parents decide partway through, oh, I don't want to do this, and they do a 10-day notice, and the children are back into foster care. We have parents who have sibling groups, and they decide they just want one of them, and they'll adopt one but not the others. That can break up the sibling group or, again, force foster care. There's all kinds of problems on the other side that would urge you to be just as cautious in making it easier to terminate and quicker to adopt. And that doesn't say anything bad about the people here today. This room is full of well-intentioned people who have a strong difference of opinion about how we ought to handle things. But you cannot create legislation to address every issue. There are lots of issues. There are lots of delays. Part of my exhibit from the Blue Ribbon panel, 35% of all first permanency hearings of Clark County were out of compliance. Only 13.58% of cases in Clark County had, as of June 2013, had required the case plan filed within the 60-day statutory limit. It has nothing to do with the parents. It's just the system. And I don't necessarily blame anyone for this. I mean, every day I work with attorneys in the DA's office and caseworkers with DFS, and I think we do really good work together. And that's what happens most of the time. The reason we don't come up here and say, oh, look at these adoption givebacks, we got to do something about this, this is horrible, is because we have a pretty good system down there, and it works almost all the time. Over the last few years, we've adopted out thousands of people, thousands of children. We have one attorney in our office who does nothing but adoption work. And most of those adoptions are done in a timely fashion. And most of those adoptions go to good, loving families who will take care of those children for the rest of their lives. So we don't want to mess with a system that works most of the time. These statutory changes will do that. For example, Section 1, I know there was a question about remoteness. We unfortunately get a lot of cases where we start out with a teenage girl as our client who then has a child. She ends up as a parent in a dependency proceeding, and the child ends up as needing an attorney because of something that happened. Well, let's say that the mother gets a case plan, but instead of doing the case plan, she decides to relinquish the rights to her child and put the child up for adoption. Well, then she hasn't completed a case plan. So if she turns around and has a child when she's 31, that child, by definition of the statute, is in need of protection, and DFS can go in and take that child with nothing more. Nothing more. And if she worked a case plan and had a child when she's 31, the child may be in need of protection, and they can go in and do an investigation on her with nothing more. This can apply to grandparents. If you want to take it way out there, parents often take over the care of their grandchildren. Well, say grandma had an abuse case 40 years ago. It's lifelong parole. This system is a lifelong parole system that you never get out of. That's the problem, and I'll stop here. I know everyone wants time. I'm already taking too much, so I'll stop and ask for questions.
Assemblyman Thompson.
Thank you, Madam Vice Chair. So, Judge Dahl, so from the scenario that you just gave, where in the bill would that relate? And then if you were to amend it so that situation in particular didn't occur, how would that be worded?
I don't know how you would fix it, but the section is Section 1. It says a child is in need of protection if a child in need of protection can be removed from the home. A child, the easiest example is a child goes to school with bruises. School personnel notice the bruises. They call Child Protective Services. There's a report made that child may be in need of protection. Child Protective Services goes to the school, and they look at the child, and they see the bruises, and they see the injuries, and that child is in need of protection, and they pull the child. So a child is in need of protection, is subject to removal from the home if a child that is in the care of the person responsible for the welfare of the child and another child has been subject to abuse by that person. So there's an abuse case from years ago, unless the person has successfully completed a plan for services that was recommended by an agency which provides child welfare services pursuant to 432B, blah, blah, blah.
Okay.
So she didn't complete a plan. There's no time limit on this. There's nothing that says what abuse is. There's nothing that requires court involvement. There's no definitions. There's no limits. There's nothing. And part of what we do, you can't just get permanency for a child. You have to get finality. And you only get permanency when you get finality. That means the case is done. These changes are going to cause more litigation. They're going to cause more appeals. They're going to raise more questions. It's going to take longer to resolve these cases. These children are going to stay in limbo longer because the parents' attorneys who are down in Las Vegas ready to testify will be raising these issues. We've had a lot of testimony today from foster parents. It's obvious they don't much like the law. Well, I don't much like the law in a lot of cases. There are cases where the law does not really favor my client. I don't care much for it because it's not helping my client. But you ignore the law at your peril. The law is the law. Parents have constitutional rights. It doesn't matter if you don't like the way it works. They have constitutional rights, and if you ignore them, this case never closes. It's never final. You have to pay attention to the law, because then when you do, the case is done. And you can do adoptions, or you can do other plans that help the kids. Another problem with this statute, and I'll end with this.
I'm going to interrupt you here. We have for fairness, we've given 30 minutes to each side, and you've taken up about 15 minutes of that 30 minutes. So just we'll give a few other folks a little a chance here. And Assemblywoman Dickman has a question for you.
Thank you, Madam Vice Chair. Gosh, I've heard so many things. I have so many questions, but I guess I'm not going to get them all. But you just talked about the parents' rights. I was just wondering about the children's rights. And it seems to me like you have a lot of heartburn with Section 3. And to me, the operative word is consider. I don't understand what's wrong with adding these considerations. And if I could also ask, you said you do what your client wants you to do. But as the child's attorney, shouldn't you be representing their best interest, their children?
No, we have causes for that. There's all kinds of people who think they know what's in the child's best interest. The judge, the CASA worker, the district attorney, the caseworker. We're the ones who listen to the child. And believe it or not, most of the time the child's right. Even if everyone else is saying something else, much of the time the child is right. They're right about wanting to go home to their parents, or they're right about not wanting to go home to their parents. We have cases where they're working on reunification, and that's the last thing in the world that our client wants. The problem with the considerations is where it's placed. It's placed in the fault section. It makes bonding with a foster parent the fault of the parent. It makes it their fault that happened, no matter what the reason, no matter what the cause for the delay. If the children bond with the foster parent, that's the parent's fault because of where it's placed in the statute.
Follow-up? But it's only one factor. But anyway, I was just going to ask you, how many children actually have attorneys?
I have about 120. There's about 20 attorneys in the office, about 2,000.
And so how many foster children would you say there are?
I'm sorry, there's over 3,000 foster. We are not to the point where we represent every child in the system.
Okay.
Okay, another question, Mr. Trowbridge.
I'll make it quick. It's been mentioned several times by the proponent and by the opposition. The proponent tells us that there's two tests that they have to pass before they can relinquish parental rights. One is the determination of parental fault, and the other is the best interest of the child. You have argued, at least I understood it that way, that by virtue of adopting 303, the fault portion goes away.
No, I'm sorry if I created that impression.
Okay,
what I'm saying is that they put bonding with a foster parent into the fault section. And that's where the problem is blaming the natural parents, because bonding takes place. If you put a newborn baby with a family, bonding occurs in about 2 days.
Where in the statute that I'm trying to read does it say it's going to put it into the fault section?
The first part is fault, and then under there's a whole list of considerations for best interest. So there's two sections. There's a fault section up towards the top, and then a couple of sections down, it's best interest. This bonding thing went into the fault portion and not into the best interest portion. In the best interest portion, it talks about bonding with foster parents and parents. It discusses both. In this fault section, it's only bonding with a foster parent.
Okay. Answer your question, Mr. Trowbridge? All right. Sir, you on the end have not spoken yet. Please do so. Please make your remarks brief because we are running out of time. Appreciate it.
Thank you, Mr. Chairman. My name is Lee Elkins. I am an attorney with the Washoe County Public Defender's Office. I was formerly a judge in Brooklyn, New York. For 17 years, I presided in dependency cases. Among the fruits of my former labor were termination of parental rights. I've done that in hundreds of cases, including many trials. I've presided over many adoptions. I've had cases where, I had one case particularly went on appeal where I fought very hard and successfully to keep a foster child in the foster home where he had lived since birth, rather than having him sent to a family in Massachusetts who were related to him that he didn't know. So I'm very familiar with these issues. Having said that, I have to say a couple of things. I prepared, or we prepared written remarks, which you should have. We also prepared an amendment or a proposed amendment to the statute, which we think addresses the foster parents' concerns and places them in the right place in the statute, which is at 108. Just quickly, Assemblyman Trowbridge, I'd like to address your question. What this statute does is it requires the court to consider in determining whether there is a risk of serious mental or emotional injury to the child if returned to the home of the child's parents, which is the grounds of termination. The attachment that the child has had or has made with the foster parent, that becomes mental harm. That's not what the statute was intended for. The statute was intended where if you have parents who have not rehabilitated, where you think that if the child goes back he's going to be mistreated, that's what it was for. But now into that definition comes this attachment to the foster parent, the length of time and placement, things of that nature, which have nothing to do with and are really beyond the control of the parent. So that's the problem. And yes, the principles are sound. They're all about best interests of a child, particularly a very young child, 0 to 3 in particular, developmental ages. And yes, they're important considerations, so they should be in the best interest section, which is in 108. And I think all of those factors are valid. The psychiatrist, child psychiatrist will tell you so. Child developmental experts will tell you so. I don't disagree with that. I just don't think it should be a grounds for termination of parental rights. If there's fault, there's fault. And then you look to see whether or not it would be bad for the child to be removed from a home where the child has been for so long. So it seems to me that's where it belongs. Assemblyman Moore, I'd like to address something that you said. You know, the fact of the matter is that Nevada has some very powerful tools in this area that this legislature has provided to the district attorney and these agencies that they don't employ. And they address your point. For example,
the agencies do not have to work with parents where there are aggravated circumstances. Among the aggravated circumstances is prior removals. If you have a child where there's been a finding of neglect or abuse, the child goes into care and then goes back to the parent and then is removed again, that's an aggravating circumstance. Agency can go to court and get a finding they don't have to work with those parents anymore. Same thing if you have a prior termination of parental rights, which I heard mentioned earlier. If there's a prior termination, the agency can go to court and get a finding they don't have to work with those parents if their child comes into foster care for a reason, for fault. Also, the point that you were making about repetitious or severe abuse, that's in there too. If you have parents who repeatedly abuse their children or have severely abused a child to the point where it's not in the child's interest to go back to those people, that's an aggravated circumstance. This is all federal law, by the way, ASFA, which was adopted by the state of Nevada. It's just not used. It's there. It's on the books. So you should know that. So this legislation is not necessary to address your concerns, frankly. I had a lot to say here. I've submitted written testimony. I would just want to address one other issue, which is the poverty of parents. This statute says if a child's been in care for 12 months, a parent can't get the child back, child has formed an attachment to a foster parent, then that's parental fault. But, I have so many clients who, particularly after, the Great Recession, people lose their homes, they lose their employment, they can't support the child. Right now, that means the child is in need of protection. Doesn't mean the parents are neglectful necessarily. If the parents have been offered assistance, but the child may still be in need of protection because the parents don't have the means. Well, it can take parents 12 months sometimes to get it together, to get a job, to get a place for a child, for example. And this proposed legislation, first of all, would raise that to neglect, which I think is unfortunate. But also, you have to look at the effects of what you're doing. I know you want to do that. I know you want to do well. I don't think we should create hardships for people who already have hardships. I don't think we should make things harder for them. And I will tell you that I have seen records of the Department of Social Services, Washoe County, where caseworkers have said that a mother with 3 kids who has no job, they have said that it's their opinion that she can't get the kids back because TANF won't support them. That even if she got public assistance, she couldn't take care of these kids. So, it's not all about child maltreatment. Sometimes it's just circumstances. And we don't want to impose greater hardships on people who are already in hardship. Finally, I'd like to quote you from the Supreme Court of the United States. It says that the fundamental liberty interest, we're talking about liberty interests, of natural parents in the care, custody, and management of their child does not evaporate simply because they have not been model parents, right? And that, or have lost temporary custody to the state. And this is what the Supreme Court said in a case involving Foster Parents Association. Foster custodians must deliver on demand not 16 out of 17, but every time, where the usefulness of foster care assignments is destroyed. The ordinary fears in placing a child in foster care should not be added the concern that the better the foster care custodians, the greater the risk that they will assert out of love and affection, growing too deep, an inchoate right to adopt. The temporary parent substitute must keep his proper distance at all costs to himself. This is the Supreme Court of the United States.
Thank you, sir.
Appreciate
it. We have allotted you 30 minutes. We need to, we have some testimony in Las Vegas. So what I'd like to do with the testimony in Las Vegas, if you're in agreement with what's been said from these gentlemen, I'm sorry that the time was monopolized up here. I apologize for that, but sometimes that's the way it goes. But if you have comments additionally that you'd like to share on some of these issues, please do so briefly. If you just want to agree, that's fine as well. So thank you for your indulgence and your patience and sitting in that small room waiting to be heard. I appreciate it.
For the record, Denise Tanata Ashby with the Children's Advocacy Alliance. In the interest of time, I concur with a lot of what's been said, not everything 100%. But in the interest of time, I will submit my comments to the committee electronically. I do want to state just for the record in this hearing, that I really, some of my concern with this bill is really around the fact that a lot of the issues that have been presented here are things that should be addressed under current law, and that I would urge this committee and our legislature to actually look at implementation and enforcement of current law to prevent some of the need for what this bill is trying to address. But I will put that all in writing to you all.
Ms. Tanana Ashby, thank you for your brevity. Appreciate it very much. Next. Probably would help if some of you would step away from the table so others can come up and sit. Those of you who've already testified or don't plan to testify. Thank you.
Very quickly, my name is Deanna Mullen. I'm an attorney with the Special Public Defender's Office in Las Vegas, Nevada. I represent parents in this process. I do agree with everything that's been said. I think they did a very good job of getting everything across. So I do just mirror that, and very, very quickly, I just wanted to say a couple things that I feel were lost in the mix. Was a lot that abuse and neglect is, it's being referred to as these horrible injuries, these children that are abused, broken bones, things like that. And a thing to remember is that in a lot of these cases, that is not the case. I myself have about 110 clients. I maybe have 2 or 3 clients that actually their children had something like bruises or broken bones. Most of the time, it is something like neglect. A huge thing is mental health. So through no fault of their own, parents have come down with a mental health condition, schizophrenia, bipolar, things like that that affect their ability to care for the children. And through that alone, they've found to have abused and neglected their children. And if, as speaking about earlier, if later on in their life they get on medication and have another child, it doesn't matter because they have abused and neglected a child earlier. The second thing I did want to discuss, what was brought up many times is that the kids need a voice. And what you've heard today from the attorneys whose only job is to represent the kids is you heard their voice. And the people who represent the children in this system are opposing this bill. Lastly, the other thing I heard was that this will not affect parents who are working their case plan and who are involved. And that is just not true, because many parents who have completed their case plan go to termination of parental rights. And I did not handle the case that was spoken about of Emma, but from my understanding, I would hope that you guys would review the pleadings in the case. But my understanding, in even the case of Emma that was brought up, those parents completed their case plan. Lastly, we talked about time delays that result in the children being in the system. That 12 months, could it be due to court delays? Yes, it can be. I was on a case where from the time of removal until the parent had their right to go to a trial, who was denying that they caused an injury to this child, that alone took 9 months. And 2 months later, they were given, 2 months after that, it went to termination of parental rights. So sorry, it was longer than I expected, but those were the quick points I wanted to get across.
Thank you very much. Appreciate your brevity. Anyone else? Okay.
Very, very quickly, Melissa Oliver. I am an attorney in Clark County. I represent parents in these proceedings. Mirror, as my colleague Deanna, mirror most of everything that what was said up north with you guys. The only thing that I wanted to make sure that the committee concentrates on is the psychiatrist spoke about attachment issues, but she focused her attention on the attachment between the foster children and the foster parents. There was absolutely no mention or attention paid to the bond between the children and their natural parents upon removal and subsequent through the process. And I'm not sure if you all are aware, but because of the limited resources here, generally when children are removed from the home, the best case scenario is that they get 2 one-hour visits at Child Haven if those visits are supervised. So that impedes their bond and increases the likelihood that they're going to bond with the foster parent. And then the second issue I wanted to make sure that light is shown upon is Mr. Trowbridge asked if anything in the bill will increase appeals. And in my opinion, Section 3, where you're asking to consider, whereas Mr. I apologize, where we're asking to consider the bond in the parental fault section of 128. In my opinion, if a finding is made that parental fault is present because of the bond of the child, that issue is going to be appealed. So I don't know if that is a fiscal consideration that should be taken note of, but those are the two biggest things in my observations today as to Section 3 that need to be addressed. Thank you.
Thank you very much. Appreciate the testimony from Las Vegas, your patience and your passion for what you do. Ms. Shin, you have 30 seconds.
Got it. Thank you so much, Chairman. Stacy Shin. Today I'm speaking for the National Association of Social Workers Nevada chapter. I am the chair of the policy committee. And I just wanted to point out that this afternoon I emailed you, or maybe it was late this morning, emailed you the story of one of my colleagues who this policy would have impacted. So if you could just check your emails and please read the story written by Jolene Dilley, that would be great. Thank you.
Thank you for your brevity. Ms. Spiegel, I know you have a question, and then we're going to wrap this up.
Okay, thank you, Mr. Chair. My question is either for Mr. Elkins or Mr. Dahl. And when I look at the bill, and there have been questions subsequent to Mr. Trowbridge's question, on page 4, lines 21 and 22, it's talking about making the finding pursuant to subparagraph 5 of paragraph B of subsection 1. And then it lists out the criteria that the question is whether or not that's fault and whether that should be considered or how it should be considered as part of the conduct of the parent. My question is, would your concerns with this bill be alleviated greatly if instead of it being pursuant to subparagraph 5 of paragraph B, if it was subparagraph 5 of paragraph A of subsection 1, which says the best interests of the child would be served by the termination of parental rights, and then this be modifying language to then clarify what those were?
Actually, thank you for the question, Assemblyman Spiegel. Lee Elkins of the Washington County Public Defender's Office. We have actually proposed putting it in 108 because that's a section that specifically addresses best interest considerations, and we agree with the principles. We just don't think it should be a ground for fault. So that's what our recommendation would be, is to take it, put it in 108. And also I think it should be balanced with considerations about the child's attachment to the natural family and also extended family, relatives, other people that may be in the child's life. Thank you.
Thank you. Ms. Joyner.
Thank you, Mr. Chair. I just wanted clarification. I'm having trouble finding on Nellis the proposed amendment, and I just wanted to know, maybe from staff, so that we have it in front of us, what it's under.
I believe it was submitted yesterday by our lobbyist, Sean Sullivan. So, but I can give you a hard copy if you need it.
That'd be great. I don't know if it met the deadline or not was the issue, so we'll see if it did. If it didn't, then we can certainly provide a hard copy for them.
Thank you very much, Mr. Chairman.
Okay, that's it. End of testimony. Any neutral? Seeing none in Carson City. Seeing none in Las Vegas. Mr. Rajo.
Sorry, Mr. Chair. There was a question that my colleague Teresa Benitez Thompson asked that wasn't answered, and I was just hoping that someone from DFS, if they have that number, could answer it for us in regards to how many children we currently have within the department that are under TPR status.
Lisa Reesley with the Department of Family Services in Clark County, for the record. In Clark County, we have approximately 100 children who are legally free, we are actively recruiting for their permanent or forever home. These children typically are the children that are highest needs children, meaning severely medically fragile, severe mental health issues. They run the gamut. It, on average, takes us about 6 months to recruit for those children, so we do move them through the system. They don't languish, generally speaking, for forever. Of the children that we have that become legally free, a great majority of them, close to 85 to 90% of them, are adopted by the foster parent that they currently reside with. You have to keep in mind that we broadly categorize foster parents, even though they may in fact be related. They may be unrelated, they may be fictive kin to the children. And so, as Bridget Duffy testified to earlier, about 55% of the adoptions that we do are relative-based adoptions.
Mr. Schiller, you see that light in front of you? See the light on the little thing? If we keep going much longer, you're going to have to use that to see there. So,
as my mother once told me, know your audience. I just was going to echo. We have averaged about 80 kids free for adoption that we're actively recruiting for, and that's been a historical number going back at least about 10 years.
Thank you, Mr. Schiller.
Amber Howell, for the record, Administrator for the Division of Child and Family Services. In the rurals, we have 40.
Answer your question, Mr. Rowe? Yes. Okay, thank you very much. Ms. Howell.
Amber Howell, for the record, just one more thing. I did send an email to Assemblywoman Benitez Thompson, so she has those numbers as well.
Thank you.
So efficient. Thank you. Senator Hammond, come and wrap it up briefly, sir.
Thank you, Mr. Chair, Madam Vice Chair, and committee members. It's been a longer hearing than I thought it was going to be, so I'll be very brief with my closing comments. First of all, I respect those who come in opposition, and so much so that I actually did listen to several of them. And in matter of fact, one of the things I think it was neglected, and I don't know if you guys heard, and I want to put it on the record, Mr. Sasser did come to Ms. Duffy, and did have some heartburn with Section 1. And so what you have before you is a collaboration between the two of them as they worked out their differences with Section 1. So that happened, and yet he still came to the table in opposition to the bill. I know that there are going to be some people who don't like it, because what we're asking for is further, more considerations to be thought of, and that puts them at odds with who they represent. I know that, and I'm grateful for some of the questions that came up. Assemblyman Trowbridge, your question I thought was timely. I think a lot of people were very confused and maybe even slightly thinking poorly when it came to, the burden of proof. I think that when you had testimony to the fact that it sounded like it was removing the burden of proof, but nowhere in SB 303, are the burdens of proof that we've talked about removed for TPR, or is TPR lowered? The standard for TPR, it's not lowered, supposedly, the way I understand it, because I was listening to some of the testimony as I had to leave for a little bit, if I say the words "with all due respect," I can then say whatever I want to afterwards. I don't think my story was any different than what I've understood it to be from the Supreme Court. And again, with all due respect, we're going to see differences of opinion. Sometimes you can't work out those differences of opinion. What I'm looking for here, I'm looking to make sure that the best interest of the child is under consideration. And in some cases, you don't have children who can speak for themselves. I mean, you talk about a newborn, a 1-year-old, a 2-year-old, a 3-year-old, maybe even a 5-year-old does not know how to communicate that to a lawyer. So passing 303 is in the best interest of the child. It's about policy. It's about further considerations. And that's all I'm asking you. That's all I'm laying at your feet right now, is to make sure we're talking about further considerations that we need to take before we make a determination. And I appreciate your patience, and that's all I'll say. Again, Scott Hammond for the record, because I think I forgot to say that. Thank you very much.
Senator, thank you. I know Ms. Duffy's just sitting there and nodding her head, agreeing with you. You did do a great job. Thank you for bringing the bill forward. Thank you for the passion from both sides. Thank you for representing your clients the way you do. We always hope we can get closer together on these issues, but as we move forward, we as a committee will work through this and process it in a work session and discuss what we need to. So thank you again for your time and efforts. With that, I will close the hearing on, forgot your bill number, Mr. Hammond, 30 what? 303. I got all these numbers in front of me. Okay, we are going to reopen the hearing on SB 459. Mr. Wilden. Welcome back, sir.
Thank you, Mr. Chairman. For the record, Mike Wilden, Chief of Staff, Governor Sandoval. During the 5-minute break a couple hours ago, I think we agreed on some language that can work in Section 16. And so if you have the reprint version of the bill, that's at the bottom of page 20, top of page 21. And the bill drafters would obviously have to clean this up. But in that lead-in sentence, in subsection 1 in section 16, is language that indicates that a practitioner shall, before initiating a prescription for a controlled substance, look up individuals on the PDMP, and that we would request to have language added there that either at the end of the sentence or wherever it fits in the middle of the sentence, for all new patients and for established patients with a new course of treatment lasting more than 7 days. I believe that is the agreement.
Dr. Titus?
I thank you, sir. That is the agreement. So I appreciate you hearing me and being willing to accept my suggestions.
Thank you, Dr. Titus.
We appreciate the committee working with us.
Is there any flavor of the committee to suspend the rules, move this forward to the floor? Yes.
All due respect, Mr. Chair, I do believe the rules state without a full committee here, we can't suspend the rules. And we're missing at least 3 members.
It's of the members who are present, Mr. Sprinkle.
That's not what I was told.
Okay, so it doesn't matter. But I believe we'll check the rules and make sure what that is, because it's supposedly the rules present. Mr. Thompson.
Thank you, Mr. Chair. Yeah, I definitely would like to get the clarification on that, because one of my bills didn't make it out because it was told that it had to be the full. No, seriously. I mean, we do need that clarification, because we do need that clarification.
Okay, Mr. Wilden, we will have a meeting and do the best we can to get this through to the floor and do what we need to do. And I appreciate your willingness to work with the members of this committee. It was an interesting hearing, and I appreciate all the thoughts that were shared by our committee members as well as the folks who testified.
Thank you, Mr. Chairman, and thank you, committee members.
And I want to go on record of thanking you also, as well as Dr. Green and our First Lady.
Okay, hearing no further business. Public comment? Without any public comment, meeting's adjourned.